Folks, welcome to WKNI TV 25 Special Report. We've been aware that this story was being compiled over the past several weeks, as are several along with this. We want to make sure that we make our audience aware that this is one of several that we're aware of that are coming through. But what it is in the United States District Court for the Middle District of Alabama, Northern Division, filed on September 27th at 3:07 p.m., Civil Action Number 2-12-CV8-837. It's a lawsuit for John W. Tisdale Jr., the plaintiff, versus Blaine Wilson, the defendant, with a demand for a jury trial. The complaint comes now, the plaintiff, John W. Tisdale Jr., by and through his undersigned counsel of record, hereby brings this complaint against defendant Blaine Wilson, and in support thereof states as follows. In this action, plaintiff John W. Tisdale Jr. seeks compensatory punitive damages for harm, damages suffered by plaintiff as the result of non-privileged, unsubstantiated, false, maliciously made, defamatory comments by defendant Blaine Wilson, published to numerous individuals in person, over W40BE television station, to Andalusia, Alabama, and electronically on Facebook. Parties: 1. Plaintiff John W. Tisdale Jr. Tisdale is a resident citizen of Fort Walton Beach, Florida, and is over the age of 19 years. Tisdale works and does business in both Florida and Alabama, including Covington County, Alabama. Defendant Blaine Wilson, who is Wilson in this, is a resident citizen of Andalusia, Covington County, Alabama, and is over the age of 19 years. Defendant Wilson is the owner of WAAO radio station and W40BE television station in Andalusia, Alabama. Jurisdiction and venue: the court has personal jurisdiction over the parties because the claims herein arise out of communications and tortious acts committed by the defendants within the state of Alabama. Subject matter jurisdiction in the court is also proper pursuant to 28 U.S.C. Statute 1332 because the amount in controversy exceeds the sum of value of $75,000, exclusive of interest and cost, and the matter is between citizens of different states. This action is properly brought in the Middle District of Alabama pursuant to 28 U.S.C. 81, as the acts of the defendant and the statements made the basis of the defamation action were published via defendant's television station in Andalusia, Alabama, and to the individuals in Andalusia, Alabama. Additionally, the negative effects of the defamatory publishing have been and will continue to be felt in the Middle District of Alabama. Count 1, defamation. For many years, Tisdale has been in the business of buying, selling, and leasing real estate and commercial properties. Tisdale does a significant amount of business in Andalusia, Alabama, where he owns numerous commercial properties at various times. Tisdale has sold properties to the city of Andalusia. Tisdale is one of the largest real estate developers in Covington County, Alabama. At some unknown time before August of 2012, defendant Wilson decided to run for the office of mayor of the city of Andalusia against the incumbent mayor, Mayor Earl Johnson. While campaigning for the office of mayor of the city of Andalusia, and at several times prior to announcing his candidacy, defendant Wilson made false defamatory statements about Tisdale that impugned Tisdale's character and integrity in violation of the laws of the state of Alabama. On or about August 2nd, 2012, at a meeting held at the Andalusia City Hall, defendant Wilson stated in the presence of several other individuals that the city of Andalusia purchased certain property from Tisdale located in downtown Andalusia, commonly known as the Bass Building. Defendant Wilson further stated that the city previously had an opportunity to purchase this same property from Wilson, grandfathered for less than what the city paid Tisdale. Wilson also stated that the city was not requiring Tisdale to abide by the contract for the purchase of the Bass Building and that there were Earl Johnson campaign signs on Tisdale's property. Mayor Earl Johnson was present at the meeting and attempted to correct Defendant Wilson and explain why the city did not purchase the property from Wilson's grandfather. Defendant Wilson interrupted the mayor and left the meeting while stating in the presence of others that the mayor could not hide the truth. The communication exchange was also published in the Andalusia Star-News on August 2, 2012. On or about August 3, 2012, Defendant Wilson also posted several statements on his Facebook page about Tisdale and the city. Specifically, Defendant Wilson published the following. Yesterday, at Andalusia City Hall, it was suggested by the current member of the Andalusia City Council, the only issue the entire City Council has not agreed on unanimously during this term in office was a decision to purchase the Bass Building, which used to be located next to the Andalusia City Hall and has since been torn down, demolished to make way for a parking lot. I spoke up and corrected this member of the City Council to let it be known the City of Andalusia did not purchase the building from the Bass family. My mother is Sue Bass Wilson. The City of Andalusia purchased this building from John Tisdale. This mayor did have the opportunity to purchase the Bass Building from my grandfather, Charlie Bass, during his first term in office for the price of $180,000. Mayor Johnson made a verbal offer to my grandfather and justified his lower offer by suggesting my grandfather Bass that he would name the Veterans Memorial Park, which was yet to be constructed at that time, after him. My grandfather stated to me, "There is no way I'm going to let the Veterans Park in Andalusia, Covington County be named after just one person. This would be an insult to everyone other veterans in Covington County." Earl Johnson did not purchase the building from the Bass family. Earl Johnson and the City Council, by a vote of 3-2, with Mr. Powell out of town on business, purchased the building in this administration for a price of $350,000 from Mr. Tisdale. According to Earl Johnson himself, in a recent meeting I had with him in his office for more than 4 hours, part of the details of purchasing this building from Tisdale was a requirement for Tisdale to spend $175,000 of this money specifically on the improvements of the Presswood Building in downtown Andalusia to make it ready for tenants. As of today, no improvements have been made to the Presswood Building in downtown Andalusia, and just might explain why Earl Johnson campaign signs have popped up on various Tisdale properties across Andalusia. Could this explain why this property owner is not complying with keeping his various properties in Andalusia clean and free of kudzu, weeds, tall grass, and collapsing roofing? Today's story in a local print tells part of the story, but not the entire story. On or about August 15, 2012, during a political speech at Oakwood Lodge in Andalusia, Alabama, Defendant Wilson also stated the following to a large group of individuals. But yet, we can go over to Cadiz Street to my good friend Alan Jordan's house, and we can take a front-end loader and dump truck and a tractor and clean up his yard. Now, I'm not saying Alan's yard didn't need to be cleaned up, but what's good for Alan is good for John Tisdale. Tisdale's yet to do anything to the Presswood Building. Now he's done some stuff over the past 10 or 12 years, but I challenge him today to show me something that he's done since November of 2010, when the City of Andalusia brought the employment buildings next to Andalusia City Hall from him and paid him $350,000. He was supposed to have spent $175,000 of those monies toward repairing the Presswood Building in downtown Andalusia to make it suitable for tenants. I challenge him to show a receipt where he has spent money on that building since November of 2010. Folks, and let me tell you what I've got, more of those letters before, that says my grass is too tall. Please cut your grass. I've got more of those letters that threaten that we're going to do this or that. Does he not get these same letters? Is he exempt from these letters? Now, I'm sorry, I got to take a drink. Now, you got to ask yourself, the building next to City Hall has been the topic of conversation. That used to be a building that my grandfather owned. It housed the employment office, the unemployment office, and it housed Army and Navy recruiters at one time. There was a large income in that building at one time, and during his first administration, Mayor Johnson came to my grandfather and wanted to buy it back because he wanted to build a veterans park. My grandfather liked the idea. He was in later years of his life. So he made Mr. Tisdale a price that he thought was affordable. Based on the amount of that income on the building that he was getting at the time, he made Mr. Johnson an affordable price as mayor to buy that building. Mayor Johnson made a counteroffer that was less and also offered to name the Veterans Park after my grandfather. My grandfather didn't like that idea. He said, "That man's crazy." Excuse me. You don't name a Veterans Park after one man. Could you imagine? We'd be a laughingstock of the community forever. What an insult to every other veteran in Covington County. So he refused to sell it for that price. My grandfather dies. My parents, my uncle, my family members again regain the control of that building, and they sell that building that was in desperate need of heating and air conditioning, roof work, and improvements. They sold that building to Mr. Tisdale at a fair and square. Mr. Tisdale sells that building to the Mayor Johnson for $350,000, the same building that he wouldn't pay my grandfather $350. Wouldn't pay $184. So I asked Mr. Johnson about it at his office. I'm reading this verbatim. 4.5-hour meeting. How do you justify giving $350 for a building you could have bought for $180? Whoa, we got him. We got him. We got him. You got who? We got John Tisdale. We got John Tisdale. He's got to spend $175,000 of that money specifically on the Presswood building, and if he doesn't, we got him. They got him, don't they? He got his sign stuck in every piece of property Mr. Tisdale owns. Vote Johnson. He got him. Mr. Tisdale's going to fix his property up. We're not just going to cut a deal because he won't go away. We're not going to cut a deal because he doesn't want to play by the rules. We're not going to cut a deal just so we can build another building or remodel another building and send more money and go more in debt. Let me tell you something. Mr. Tisdale decides to buy the property. Mr. Tisdale needs to fix up his property. Do you agree? The above speech was recorded and was replayed on numerous occasions by Defendant Wilson on his television station W40BE in Andalusia, Alabama, during the month of August 2012. These communications contain false and inaccurate statements about Tisdale. These communications also falsely agree and imply that Tisdale was involved in illegal, dishonest, and corrupt practices and that he was receiving illegal special treatment from the city and the incumbent mayor, Earl Johnson. Specifically, Defendant Wilson attempted to convince the citizens of Andalusia that 1. Tisdale entered into a corrupt, illegal deal with the city for the sale of the Bass Building, whereby Tisdale received $350,000 from the city, which was more than the city should have paid. 2. That Tisdale was not abiding by the sales contract, which specifically directed him to spend $175,000 on improvements to the Presswood Building in downtown Andalusia. And 3. That the city was acquisitioning, I believe it is. It's ACQUIESCING, in Tisdale's breach of contract, not enforcing the contract against Tisdale, and not enforcing applicable nuisance laws against Tisdale in exchange for Tisdale placing Earl Johnson mayoral campaign signs on Tisdale's property. The statements made by Defendant Wilson implicate Tisdale as being involved in corrupt and dishonest practices with the city when the true facts are to the contrary. Specifically, the Bass Building was owned by the defendant's family and was listed for sale by the Bass Agency November of 2008 for $349,500. Defendant Wilson's mother asked Tisdale if he would purchase the property, and he agreed to pay for buy the property in 2008 for $300,000. In December of 2010, Tisdale sold the Bass Building property to the city for $350,000. This was $500 more than the list price for the property in 2008 when the family owned the offered and in 2008 when defendant's own family owned the property for sale. Despite the true facts, Defendant Wilson persisted in a public campaign to incite the public into believing that the city and Tisdale entered into a corrupt, illegal deal whereby Tisdale received a financial windfall of $350,000 from the city. In fact, taking into consideration numerous costs for taxes, maintenance, insurance, and bank interest, Tisdale made only a profit of approximately $28,000 when he sold the building to the city. Additionally, as part of the consideration for the sale of the Bass Building to the city, Tisdale also agreed to make substantial improvements to the downtown area of Andalusia. Contrary to the Defendant Wilson's statements, Tisdale did not contractually obligate to make improvements to the Presswood Building in downtown Andalusia in the amount of $175,000. Sales contract between Tisdale and the city provides that Tisdale is to make improvements in the amount of $175,000 to the downtown area of Andalusia, with the Presswood Building being one of the highest priority. Defendant's statement that Tisdale is not abiding by the contract due to his alleged failure to make $175,000 of improvements to the Presswood Building is false. Defendant's statement that Tisdale has also breached the contract because he has not made any improvements to the Presswood Building is likewise false. There is no breach of the sales contract by Tisdale, and no that word again, ACQUI, acquisitioning, okay, by the city in any alleged breach in the exchange for Tisdale's, I love her being over there, Tisdale placing Earl Johnson campaign signs on his properties. Contrary to the statements made by the Defendant Wilson, there is also no alleged or corrupt deal or arrangement between the city mayor, Earl Johnson, and Tisdale, whereby the city has agreed not to enforce its nuisance laws against Tisdale. In fact, Tisdale has received abatement notices from the city and has abided by each such notice. Tisdale sold the property, the Bass Building, to the city in an arm's length transaction. Defendant Wilson's public statements implying that there is some type of corrupt and illegal deal between the city, Earl Johnson, and Tisdale, and that the city is receiving special and or preferential treatment from the city and Earl Johnson are false, misleading, and simply inaccurate. The above statements published by the Defendant Wilson are false and containing words that impeach Tisdale's professional reputation. These disparaging words also affect Tisdale in ways that are peculiar. Yeah, I've been reading too many words. Peculiarly harmful to one engaged in the business of buying, selling, and leasing real estate and commercial properties. These statements have harmed the reputation of Tisdale by lowering him in the estimation of the community and deterring third parties from associating and doing business with Tisdale. Furthermore, such statements charge offensive and that would tend to cause Tisdale to be the subject of public hatred, contempt, or ridicule. These false statements have harmed the reputation of Tisdale and have caused prejudice to Tisdale business and trade, and therefore defamatory per se. Defendant Wilson published these statements either recklessly without regard for the consequences or intentionally with the intent to harm or defame Tisdale. In the alternative, defendant Wilson negligently made such defamatory comments about defamatory statements about Tisdale. I'm trying to read this word for word. Only a few more pages. As a proximate result of these defamatory statements, Tisdale has suffered loss of reputation, loss of standing in the community, loss of business deals and opportunity, and has been caused to be viewed with skepticism and mistrust by present and future business prospects. Defendant's defamatory statements have further caused plaintiff Tisdale to suffer significant emotional distress. On August 27, 2012, Tisdale formally demanded that defendant Wilson retract false and defamatory statements defendant Wilson made about Tisdale. As of the date of the filing of this complaint, defendant Wilson has not printed or otherwise published any retraction. Wherefore, the premise considered, plaintiff Tisdale demands judgment against defendant Wilson for compensatory damages in excess of $75,000, exclusive interest cost plus cost and attorney's fees, and any other relief to which Tisdale may be entitled. Count 2, punitive damages. Tisdale restates and incorporates herein the allegations in the foregoing paragraphs as in the same were set out here in full. Tisdale has given defendant Wilson the requisite time to retract the defamatory accusations made the basis of his suit before filing an action requesting punitive damages. As of the date of this filing, defendant has not retracted the defamatory statements. Wherefore, the premise considered, Tisdale demands judgment against defendant Wilson for punitive damages in the amount to be determined at trial, such award being significantly punitive in order to prevent the defendant from engaging in such defamatory conduct in the future. Tisdale further requests any other relief to which he may be entitled. Count 3, injunctive relief. Tisdale restates and incorporates herein the allegations in the foregoing paragraphs, and the same were set out here in full. In August of 2012, defendant Wilson published false defamatory statements about Tisdale in public meetings, on Facebook, during a political speech, and on the defendant's television station in Andalusia, Alabama. Defendant Wilson alleged and implied that Tisdale was involved in a corrupt and illegal deal with the city and Mayor Johnson, whereby Tisdale was paid too much money for his sale of the Bass Building to the city. Defendant Wilson also alleged and implied that Tisdale was in breach of the sales agreement by not making required improvements to the Presswood Building in the amount of $175,000, and that the city was, I'm just going to say acquiring it, it's that word again, acquisitioning, there we go, I'll get it, in Tisdale's breach of, in exchange for Tisdale's political support of Mayor Johnson. Defendant Wilson further alleged and implied that Tisdale was receiving illegal preferential treatment from the city and Mayor Johnson, i.e., the city was not enforcing its nuisance laws against Tisdale in exchange for Tisdale's political support of Mayor Johnson. Such false and defamatory statements have harmed Tisdale's reputation by lowering him in estimation, I believe it is, well, esteem, of the community, and have deterred third parties from associating with Tisdale and or doing business with Tisdale. Furthermore, such statements charged offensive would tend to bring Tisdale into public hatred, contempt, or ridicule, and directly tend to prejudice Tisdale in his trade and business, and therefore defamatory per se. Defendants' defamatory statements have created a present time diminution, that's D-I-M-I-N-U-T-I-O-N, I should have been an attorney, I guess, of reputation in the community for Tisdale. Defendant defamatory statements have harmed Tisdale and will continue to lead to harm and prejudice to Tisdale, for which monetary compensation will be insufficient. If the harm is to Tisdale's reputation is to be solved or stopped, defendant Wilson must retract the defamatory statements If such statements are not retracted, Tisdale will suffer immediate and irreversible injury, which will be difficult to assess or compensate with monetary damages. Wherefore, the premises considered, Tisdale requests that an injunction be issued against Defendant Wilson, requiring Defendant Wilson to immediately retract the defamatory statements made on the basis of this suit, requiring defendant to publish such retraction, forbidding defendant from publishing further false and defamatory accusations against Tisdale, and granting Tisdale and any other equitable relief to which the court finds he is entitled. Count 4, intentional interference with business relations. Only a page and a half left. Tisdale restates and incorporates herein the foregoing allegations as if the same were set out here in full. At various times in 2012, Defendant Wilson alleged and implied that Tisdale was involved in corrupting an illegal deal with the city mayor Johnson, whereby Tisdale was paid too much money for the Bass building. Defendant Wilson also alleged and implied that Tisdale was in breach of sales agreement by not making required improvements of the Presswood building in the amount of $175,000, and that the city, there we go, was acquisitioning in Tisdale's breach in exchange for Tisdale's political support of Mayor Johnson. Defendant Wilson further alleged and implied that Tisdale was receiving illegal preferential treatment from the city, and Mayor Johnson in the city was not enforcing its nuisance laws against Tisdale in exchange for Tisdale's political support of Mayor. These statements were false and were published by the Defendant Wilson maliciously, wantonly, or recklessly without regard for the consequences. Tisdale lost business opportunities, contracts due to the false, misleading, and defamatory statements that were published by the defendant. Defendant Wilson acts in publishing the false and misleading statements constitute intentional interference with Tisdale's business and contractual relations. As a proximate result of these intentional acts, Tisdale has suffered financial loss, damage to his reputation in the community, and sufficient emotional distress. Wherefore, the premise considered, Tisdale demands judgment against Defendant Wilson for compensatory damages in excess of $75,000, exclusive of the interest and cost, and punitive damages in the amount to be determined by a jury, plus interest, cost, and attorney's fees. Jury trial demanded. Thomas T. Gallen III and Constance C. Walker, attorneys for plaintiff John W. Tisdale, of counsel of Haskell, Slaughter, Young, and Gallen, LLC, located in Montgomery, Alabama. And that is all 12 pages. I want to stress to folks that watched all this going on, and we're going to talk about it in just a moment. We too became party to some very vicious attacks by Mr. Wilson. And we feel that. And we are concerned about it. We have also made our own contacts on it. We have suffered because of some of the statements and some of the accusations made, and we are going to pursue that. There are other people that are pursuing it as well. What the bottom line is here, folks, I'm not worried about Mr. Wilson or Mr. Tisdale or anybody else. I watch on Facebook daily people going after people saying things, and they're not being held accountable. This is a fact that you can be held accountable for what you post on Facebook, and most assuredly, we know what you can and can't say on television and in the media. That's why you've got to be very careful with what we produce right here in the television environment or on a newsprint or radio. You've got to be mindful of the repercussions that you have with the individuals involved. You have to know that you are not being personally involved in it and attacking somebody on your own persona, against an individual without factual or basis to it. Again, there are several people that are pursuing legal action that we're aware of. We have been told of anyway. Whether they proceed to or not, we are considering and looking into it as well. We are not W-static TV. My wife is not what she's been called publicly on Facebook. And I advise that to cease and desist as well. Now, it's not nice, it's not pretty. We've done nothing, we've left everybody alone in this. But when the story comes out, we'll bring it to you. We'll let you know, Mr. Wilson's, we called Wayo this afternoon, or I did. An individual answered the phone, I explained to him who I was, and the phone was hung up. So I do not have a comment from Wayo. I did talk with John Tisdale today after I received this information from my sources that I have in Montgomery. And that Mr. Tisdale said that yes, he did file the lawsuit, and yes, he intends to pursue it to every extent that he has, and that any further questions need to be referred to his law firm. So with that being respected, that's the way it is, and that's the way it was. Remember, folks, this and this can hurt people innocently, even though you may not like somebody, even though you may have something against them. Be mindful, you can be held accountable for publicly acting on it by libel, slander, and I also understand this fell under, according to the clerk, assault somehow. I don't know. But when I asked the clerk today, when I called up there and talked to her, she said that the lawsuit was for libel, slander, and assault. And I asked again, what's the assault? She said that's part of the lawsuit. So, I don't know. Maybe the lawyers out there can figure it out. That's what I was told in the conversation. And that's all we'll bring to you is the facts. WKNI TV 25 has stood on the facts and the information for the past 8 years that we've been broadcasting to you. And that's the way we're going to be. This is Eddie Lewis reporting for WKNI TV 25. Thanks for tuning in.